A pass-through will is a simple will which leaves all of your assets to your trust. Why is it needed? As part of your estate planning, to avoid court probate process and potential litigation, we are creating for you a trust. We will also work with you to either actually transfer your assets to the trust or to name that trust as a beneficiary. Otherwise, the trust remains an empty shell. A good planning ensures that the vast majority of assets are in the trust at the time someone dies. However, sometimes assets will remain outside the trust. Maybe it's the apartment that never got transferred. Maybe it's a bank account that was forgotten. Maybe it's a lawsuit settlement that materialized because of a fatal accident. Regardless, there are plenty of circumstances when assets remain in the decedent's estate and therefore a will is needed to direct who is in charge and how these remaining assets shall be distributed. This will is then going to be submitted to court. So let's go through the specific provisions in this document. In Article 1, you declare that all of your previous wills are now revoked and only this latest one remains valid. There can only be one valid will, and it is the latest one that you signed. In Article 2, you explain your family situation. Regardless of how you want to leave your assets, you need to acknowledge the existence of your closest relatives. Yes, this is true even if you want to disinherit them completely. Otherwise, these relatives can later contest your will, claiming that you were not in your right mind when creating this document, since you forgot about their existence. We have seen clients forget about estranged children, half-siblings, and separated spouses. Please trust us, you need to acknowledge their existence here, even if you are not leaving them a penny of your assets. Article 3 is the main portion of the will. First, you appoint the executor. This is the person who will be in charge of collecting your assets, paying any outstanding bills, and distributing the assets in accordance with your wishes. You want to name someone who you trust and someone who is financially responsible. It can be a family member, a friend, or a professional. It may or may not be one of the beneficiaries of your will or trust. Second, you appoint a guardian for your minor children, if any. This is the person who will be making all legal decisions for your children until they turn 18. Third, you tell the court that the executor does not have to post a bond. What does that mean? A bond is a security deposit to ensure that your executor does not steal the assets from the beneficiaries. To post a bond, the executor has to pay a third-party reputable specialized company, and then this bond company guarantees the funds to the estate in the event the executor does steal the money. If there are no such provisions, under many circumstances, such as for example when there is a dispute amongst the beneficiaries, the court usually makes the executor post a bond. It is a hassle. Some people simply do not qualify, based on their lack of income or a low credit score, and it is always an additional expense to the estate. Here, you can say that you trust your executor, so that no bond is needed. Ancillary administration means administration of assets in different states or countries. So if you have a property in Florida or a bank account in Switzerland, the same person who you have named as an executor above will be able to administer the assets in another state. And here is where you actually declare how you are leaving your assets. Since this is a pass-through will, you are simply stating that all of your assets are being left to your spouse if the spouse survives you and wants the inheritance. If there is no surviving spouse or if he decides to disclaim the inheritance due to tax or creditor reasons, then 100% is being left to the family trust. There is no need to get into any additional specifics of the distributions. You will do that in the trust document. Article 4 is the administrative section, giving instructions to the executor. Here you tell the executor to pay the estate taxes, if any, proportionally from all your remaining assets. Here you explain that the executor shall be compensated reasonably for their work. Reasonably means based on the New York statute that sets compensation for executors in the state. In addition, the executor shall be reimbursed for any expenses that they paid out of their own pocket on behalf of the estate. These are usually legal fees, court filing fees, and funeral expenses, if any. Here you give the executor all the powers allowed under the laws of the state of New York to act properly. You trust the executor to act reasonably. Article 5 is miscellaneous, to help the court with any ambiguities. The contest provision explains that anyone who is contesting the will is going to lose his share of the estate completely. Rules of construction are there for any issues with grammar, explain that the will is to be interpreted under New York law, and explain that the invalidity of one provision does not mean that other provisions are also invalid. Then you sign your will. You need to sign the will in front of 2 witnesses and a notary. We will be providing all of these. You will be signing in front of an attorney as well, as in New York the will is presumptively valid if it was signed in front of an attorney. You will declare aloud this document to be your last will and testament, as it is one of the requirements. You will ask your witnesses to witness the will, as it is one of the requirements as well. Your witnesses will sign twice. First, on the bottom of your signature page. And then again, they will sign an affidavit, with language that is required under the law of the state of New York. The witnesses basically acknowledge that they have seen you sign, that they have seen each other sign, that you are mentally capable of understanding what you are signing, and that you are under no duress to do so. The witnesses' signatures will be notarized.